So once you have a matter in court, if you have engaged a lawyer, then you should normally appear through lawyer. In the case of Mamta Banerjee, she already had a lawyer in court, and accordingly, she should ideally not have appeared in person, because if you want to appear in person, you have to discharge your lawyer. So that was more of theatrics, so to say, because she knows that if she appears in court and makes some sound, it will get eyeballs and it will be widely published. So it was more for the media than for the court. And Supreme Court also was kind to her. Supreme Court could have snubbed her and said that either you argue yourself or you argue through your lawyer. You can't have the best of both. So that was more of theatrics. Even here today, Kejriwal had not engaged a lawyer till today. And I don't think if they were asked to argue their matter, they would be properly qualified to argue it also themselves. This is more of a public eye. Legally, there is no bar. Every client has a right to argue himself if he decides not to engage a lawyer. But if he has engaged a lawyer, then court normally does not permit the client himself to argue, which was done as an exception only to not insult Mamta Banerjee by saying that sorry, you can't argue because you have a lawyer. That would have been an insult to her, and that would not look nice because she is holding a constitutional position. So the court was, quite tolerant in letting her say a few words in spite of her having a lawyer, and allowed her that day in the sun. But this is more of theatrics than actual addressing the court.